Dear friends, good morning to all. This is your RAPETI Suryanarayana, advocate from Visakhapatnam. In the earlier sessions, I gave many topics with regard to, I gave many lectures with regard to various topics. All the topics are useful to the common public, to practicing advocates, and to law students, and also to the students who are appearing for competitive exams. In the previous session, I gave lecture with regard to first information report. And some more important points are there with regard to the information. That is first information report. Let us discuss in this session with regard to much more important points about first information report. In the previous session, I said that if the information given by a suffered person or relative of the suffered person or friend of the suffered person to the police officer with regard to the offense alleged to have been committed or attempted to have committed, then the police officer will record that information in writing, or if the given complaint in writing by a complainant, then the police officer will take that complaint, enter in a book which is kept for that purpose in the police station, and make an investigation with regard to that case if that information discloses commission of cognizable offense. If the complaint give orally with regard to the information related to commission of cognizable offense, then the police officer will reduce that oral information in the written form, in writing on the paper, and will take signature of the informant on that paper and enter that information in a book which is kept for that purpose in the police station as prescribed by the state government, and he will investigate with regard to such offense. And also I said that if he refuses to record the information which discloses commission of cognizable offense, then the complainant have an option to send that information in writing by post, in writing and by post to the superintendent of police if the police station is in the limits of rural, or to the commissioner of police if the police station within the limits of urban or city limits, then the superintendent of police or commissioner of police will take action on it. If the information discloses the commission of cognizable offense, he himself will investigate that case, or he will direct to any his subordinate officer to make an investigation with regard to that offense. Here in the earlier class I said that the information relating to the commission of a cognizable offense, okay, the information relating to the commission of a cognizable offense. If the information is relating to the cognizable offense, the police officer receives information. Okay, and enter in a book. Up to that extent, we have discussed. If the informant is a woman, that means the suffered person or victim is a woman, or against woman and harm or injury or loss caused or attempt caused by any person, then what this woman have to do? This woman will go to the police station and give complaint against such person. Here she is a woman. Caused an offense against the woman. Then woman will go to the police station to give information which discloses commission of cognizable offense. That means offenses related to the woman. Then in the police station, woman police officer shall record the information given by the woman complainant or woman informant. Okay, is it clear? Why? Because the offense is related to the woman. What are the offenses related to the woman? Like 354, 326A, rape cases, 509, outrage the modesty of woman. All these offenses related to the woman. And the victim or the woman who suffered loss or injury shall give the information which discloses a cognizable offense to the police officer. And in the police station, the woman police officer shall record such information given by the woman victim, or any woman police officer shall record the information given by the woman victim. Next, what happened? Next, in the same way, that woman police officer shall enter that information in a book which is kept for that purpose. And if that information discloses the commission of a cognizable offense, and investigate into that offense. If the person, suffered person or victim, is temporarily or permanently mentally or physically disabled person, if the person is disabled person, he is not in position to go to the police station, then how? Here the victim is a disabled person. He want to give a complaint to the police station. He want to give a report to the police officer. Then how it is possible to this person? Then the police officer will record the information which discloses commission of cognizable offense at the residence of the person who seeks to give report to the police officer, or at the convenient place where the informant or complainant choose, at the convenient place where the complainant choose to give information which discloses commission of cognizable offense. That means if the person is suffered mental or physical disability, whether it is permanent or temporary, he is a disabled person. He want to give a complaint to the police officer. Then the police officer will come and take the complaint or record the information which discloses commission of cognizable offence at the residence of the complainant or at the convenient place which the complainant chooses to give the information. This information will be recorded in the presence of interpreter or special adjudicator. In the similar way, if the woman is a disabled person, and she is a victim, she has suffered injury or loss, she is a disabled person physically or mentally. The disability may be temporary or physical disability. She wants to give a complaint with regard to the offences related to the woman, like rape cases, outrage the modesty of woman, etc. In these cases, the police officer will record the information at the residence of the complainant or informant or at the convenient place which the complainant chooses to give information which discloses the commission of cognizable offence in the presence of interpreter or special adjudicator. Next, here I said about the information which discloses the commission of cognizable offence, and the police officer record that information which discloses commission of cognizable offence. That means this is information in cognizable cases. Procedure with regard to information in cognizable cases. If that information discloses non-cognizable offence, if the person has suffered some loss or injury or any loss or injury, and that person goes to the police station and give a complaint to the police officer or give information to the police officer, and that information discloses commission of non-cognizable offence or non-cognizable case, then what the police officer have to do here? Whether the police officer have a power to investigate? On that, let us see in this session. If the information given by the informant or the victim to the police officer which discloses non-cognizable offences, which discloses commission of non-cognizable offence, then the police officer shall record that information in a book which is kept in the police station in such form as prescribed by the state government. That means the police officer shall record the information in a book which discloses the commission of cognizable offences which is stated by the informant or victim. After entered or caused to be entered in a book in a police station which is present in the police station in a prescribed form by a police officer, then the police officer shall refer the informant to the magistrate. Then what the police officer have to do? The police officer shall refer the informant to the magistrate. Why? Because the information given by the informant or the victim is disclosing the commission of non-cognizable offense. That information is not disclosing cognizable offense. Is it clear? This is very important point. The information stated by the informant or victim to the police officer is disclosing non-cognizable offense. So, the police officer shall enter such information which discloses non-cognizable offense in a book which is kept for that purpose and refer the informant to the magistrate. Next, what will happen? Then, here the police officer has a power to investigate. No. No police officer shall have the power to investigate a case or offense relating to the non-cognizable offense or case. What I said? No police officer shall have a power to investigate a non-cognizable offense without order from the magistrate. Once again I am repeating this point. No police officer have power to investigate a non-cognizable offense or case without order from a magistrate who is having power to take cognizance of the offense, to try such case or to commit the case for trial. Okay, is it clear? That means the magistrate should be a competent magistrate to try such offense or to commit such case for trial. The magistrate shall give power or order to the police officer to investigate. Without order from the magistrate, the police officer have no power to investigate non-cognizable offense. Why? Because it is a non-cognizable offense and the information discloses non-cognizable case. Okay, is it clear? I hope it is clear to all. No police officer shall have a power to investigate a non-cognizable offense without order from a magistrate, and such magistrate should be competent magistrate to try such offense or case or to commit such case for trial. Next point. If the magistrate order to a police officer to make an investigation with regard to the commission of non-cognizable offense or case, if the magistrate order any police officer to make an investigation with regard to the non-cognizable offense or case, then what the powers this police officer will have? The police officer will have all the powers, or the police officer shall exercise all the powers as same as officer in charge of police station exercise in cognizable offense. Is it clear? If the magistrate order any police officer to investigate a non-cognizable offense, then the police officer shall exercise same powers, in respect of an investigation as an officer in charge of police station may exercise in cognizable case or offense. This is an important point. Try to keep in your mind, make an attention with this point, very important. If a magistrate order any person to make an investigation in a non-cognizable case or offense, then the police officer shall exercise the same powers in respect of an investigation as the officer in charge of police station have powers to investigate a cognizable case or offense. That means whatever the powers officer in charge of police station exercise in case of cognizable offense or case, the same powers will exercise by this police officer in a non-cognizable offense. Why? Because this police officer have order from the magistrate to investigate a non-cognizable offense. So this police officer have same powers with respect to the investigation of non-cognizable case as in the same manner as officer in charge of police station investigate in a cognizable case. I hope it is clear to all. Whatever the officer in charge of police station have powers to investigate cognizable case, the same powers will have to this police officer to investigate a non-cognizable offense. Why? Because the order is passed to this police officer by a magistrate. That means with the order from the magistrate, this police officer have a power to investigate a non-cognizable offense and exercise all the powers as an officer in charge of police station exercise in commission of non-cognizable offense. I hope it is clear to you all. For example, if a case relates to two or more offenses, if a case relates to two or more offenses, or if the informant or victim, that means a person who has suffered any loss or injury, come to the police station and give a complaint to the police officer, and that information which is given to the police officer discloses two or more offenses. That is, the case discloses two or more offenses. In the two or more offenses, one of the offenses is a cognizable offense, and remaining all the offenses are non-cognizable offenses. Then how we have to consider that case or offense as a cognizable or non-cognizable offense? Here I said that the information given by the informant or the complainant to the police officer, that such substance of information discloses two or more offenses. In that two or more offenses, there is one offense, that is cognizable offense, and remaining all are offenses related to the non-cognizable offenses. That means case relating to two or more offenses of which at least one is a cognizable and remaining all are non-cognizable offenses. Then such offense shall be deemed to be a cognizable offense or cognizable case, even though other offenses are non-cognizable offenses. I hope it is clear to all. If the information discloses two or more offenses, among the two or more offenses, if any one of them discloses the commission of cognizable offense and other information discloses commission of non-cognizable offenses, then such offense shall be deemed to be considered as a cognizable offense or cognizable case, even though other offenses are non-cognizable offenses. That means it shall be deemed to be a cognizable case. Once again, I would like to repeat this point. Where a case relates to two or more offenses, of which at least one is a cognizable offense, then such offense shall be deemed to be a cognizable offense or cognizable case, even though remaining all or others offenses are non-cognizable offenses. If any one of the offense is cognizable offense, then it shall be deemed as cognizable case or cognizable offense, even though remaining all are non-cognizable offenses. That is the important point here. That means in this session I said that if the information discloses commission of cognizable offense, the police officer have a power to investigate without an order from magistrate. Is it clear? Once again I would like to repeat. If information discloses the commission of cognizable offense, then the police officer have a power to investigate the offense without order from the magistrate, who is competent to take or try such case or commit such case for trial. If the information which discloses commission of non-cognizable offense, then no police officer shall have a power to investigate into the non-cognizable case or offense without order from the magistrate. I hope it is clear to all. That means for investigation purpose, there must be an order from the magistrate to the police officer. If the information discloses non-cognizable offense. If non-cognizable offenses, the police officer have no power to investigate without order from magistrate. If cognizable offenses, the police officer can investigate the offense without order from the magistrate. I hope it is clear. If information discloses commission of cognizable offense, then the police officer shall investigate the offence without order from the magistrate. Why? Because here the offence is cognizable offence. If the offence is cognizable offence, the police officer have a power to investigate the case without order from the magistrate. If the information discloses commission of non-cognizable offence, then no police officer shall have power to investigate such offence, which is non-cognizable offence, without order from the magistrate. I hope it is clear to all. That means there must be order from the magistrate to investigate the offence by the police officer. Why? Because it is a non-cognizable offence. If the police officer receives information, if the police officer receives information which discloses offences relating to the woman, then such information shall be recorded by the woman police officer. Why? Because the information is related to the woman, like rape cases, and such information shall be recorded by the police officer, woman police officer, where the police officer have to record such type of information with regard to rape cases. The police officer shall record the information at the residence of the victim, at the residence of the victim, or at the convenient place where the victim choose to give information to the police officer. The police officer will come and record the information with regard to rape cases at the residence of the victim or woman, victim woman, or at the convenient place where this victim woman chooses to give information with regard to the rape case. Here, in the presence of relatives or parents or guardian or social worker, the police officer shall record the information from the woman victim, which information discloses the commission of rape offense or offenses related to the woman. If the person, victim person, is mentally or physically disabled person, whether the disability may be permanent or temporary, it shall be videographed. It shall be videographed. That means the recording of such information which discloses commission of offense shall be videographed. Why? Because here the victim is a disabled person. That disability may be mental or physically, or it may be temporary disability or physical disability or permanent disability. Whatever it may be, the recording of such information which discloses the commission of offense shall be videographed and also shall be taken in the presence of special adjudicator or interpreter. I hope this session is clear to all. Kindly like my videos and share my videos and subscribe my channel. Thank you all. Thank you.